When you sue your doctor for medical malpractice, is it ever advantageous for the doctor to turn around and simply admit that he was wrong? You want to know the answer to the question? Come join me on this walk in St. Martin on this deserted island as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is yes, in some instances, it is advantageous for the doctor and his attorney to actually admit that they did something wrong. Now, does that happen often? The answer is no, it does not happen very often. So what's the scenario? What am I talking about here? All right, so you believe your doctor was careless, causing you significant harm and injury. Your doctor goes ahead and says, hey, I did nothing wrong, and even if I did something wrong, whatever I did not cause or contribute to your injuries. And then he says, you know what? If I did something wrong, so did you, Mr. Patient. And then he says, listen, if I did something wrong and I caused you harm, your injuries really aren't that bad. So those are the typical defenses that we see in these medical malpractice cases. Okay, so now what's the scenario I'm talking about? I'm talking about a scenario where we believe the liability is clear-cut, meaning that we believe that the doctor violated the basic standards of medical care, and it is so obvious that there's no possible way that they can honestly defend this part of the case. So what happens then? What happens then is that now the doctor and his attorney will go ahead and evaluate the case. They will determine for themselves whether or not what we are claiming is true. If it turns out that the doctor's actions are indefensible, now it may benefit the doctor and his attorney to simply short-circuit the entire litigation process. And what does that mean? It means we no longer have to go through the discovery process to evaluate and determine whether or not the doctor was careless and whether or not he violated the basic standards of medical care. If the doctor actually goes ahead and admits and accepts responsibility, now the only real issue is, okay, what is the extent of your injury? How badly are you damaged? What are your damages? What type of harm did you suffer? And now the entire case will then focus on your injuries. So why would he do that? There are a couple of instances where the doctor and his attorney might do that. The first is where his conduct was so egregious, so outrageous, so obvious, that if they go to trial and now get in front of the jury, it is quite likely that the jury will be outraged. It is quite likely that hearing what the doctor did or did not do will inflame the jury so much so that now it's going to affect their decision on how much money you are to receive as a result of this doctor's carelessness. So it has a direct correlation. If the doctor's actions were so outrageous, so careless, so neglectful, now it may inflame the jury. Now they may get very incensed and very, very upset. And that could have a negative impact on the amount of damages, the amount of money that they actually give to you from the defense standpoint. So they may turn around and say, you know what? If we avoid having to go through that entire process and not have to give the jury that information, now we're simply going to have a trial on damages to determine and assess how much money you are to receive for all the harms and losses and damages that you incurred because of what this doctor did. So that may be a key reason why they strategically will say, you know what, better for us to actually admit it, now move on. So now the only thing that we're going to do during the course of a trial is, okay, ladies and gentlemen, the doctor has admitted that he was careless and that his carelessness was a cause of this patient's injuries. The only reason you are here is to determine how much money this patient is to receive. Simply because the defense admits liability and accepts responsibility that what he did caused you harm and injury does not mean that they're going to simply roll over when we ask the jury for a specific amount of money. They're still going to fight us tooth and nail to try and minimize the amount of money that we believe you should be receiving for all of your injuries and damages. And so why do I share this quick information with you? I share it with you because I happen to be on a deserted island here in St. Martin. My wife is picking seashells, so I have a few minutes to share this great information with you, and I wanted to explain to you how this process works. You know, I realize you're likely watching this because you wanted to see the beautiful scenery. No, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.